designed to undermine their credibility is inappropriate. And I indicated in the motion there were times that the court continued in its behavior, its tone, its manner, directing towards me what was clear that the court was either dismissive or sending signals that the jury would naturally think that I was doing something wrong. When I was doing my closing argument, I was to the right hand of where Your Honor was sitting, the jury box was on that side. When my back was turned to the court, the jurors continuously looked up to, like over my, kept looking up toward Your Honor. 2 times during the course of my closing argument, Your Honor, on her own, no objection, interrupted me and indicated there is no evidence of that, that's to be stricken. Both occasions, that was absolutely not inappropriate, but it was absolutely wrong. There was evidence on both times. I had indicated that a picture which had the defendant holding a firearm that was consistent with the firearm used in the killing, I indicated that was taken in December, which were mere weeks before the killing of Edwin Medina, the 15-year-old boy. The court said there was no evidence of that, sustained it, struck it, and in fact, there was evidence of that. It was not contested by the defense attorney. In fact, he didn't contest it, and that's reflected in the record, because his client had been in the state prison till about December 3rd or December 5th of 2007. The picture came, and you'll remember there was a witness, Joshua Oliveira, who testified. He had enlisted in the military. He had come home in December, and on that occasion, he was walking by, there were some people there, he ended up in the picture. So he was able to date it through his testimony. There was also Mr. Coleman, who dated that this picture had been taken a couple of weeks before the shooting. The court further undermined my credibility as I argued this case. And again, I said to this jury, the defendant is absolutely entitled to a fair trial, but the Commonwealth is entitled to the same fair consideration of the evidence. I said at least 6 times, you're to decide this case on the evidence, not on these other things, on the evidence. That's how you'll render a fair verdict in the case. I at some point indicated the defendant, after he had shot Mr. Medina to death, he ran down the corner. People from the party started to chase him. You'll remember some distance, the next block, he stopped and fired a couple of additional shots to keep the people from chasing him. I used the word chase. Your Honor interrupted me and said, there's no, strike that, there's no evidence of that in the case. Well, there absolutely was evidence of that in the case. Xiomara Pineda indicated in her testimony she saw people chasing after the person who had done the shooting. Edgar LeBron also indicated that he had joined other people chasing up until the corner, and then the shots were fired, and at that point they disbanded. Throughout the course of the case, I noted that there was what I perceived to be a disparity in the manner in which you engaged myself, and that you didn't engage the defense attorney in the same manner. In his closing, the defense attorney injected personal opinions. He argued facts that were not in evidence, and he also misstated evidence. There was never any interruption. There was never a rebuke or never any statement that, in fact, that there was no evidence what he was trying to argue. So I was rebuked in the course of my closing argument for things that were actually in evidence. He was suggesting things that weren't, and there was no rebuke. Your Honor, this was not a motion that I filed to judge shop, to do anything other than to bring attention what I thought was antagonism and an unfairness in a case that obviously will disagree about certain rulings, but we expect the same right to be treated in a manner equal to the other attorneys, and also the same right to present our evidence and to get a fair trial. We filed this motion to address this issue and resolve it this time. Your Honor, I'd ask that ADA Roger Michael be allowed to address the court on the issues of law.
Good morning, Your Honor. Roger Michael for the Commonwealth. In my portion of the presentation, I'd like to focus on a number of the allegations contained in the defendant's opposition to our motion to serve as a sort of entry point for making clear both our own position as well as our motivations in taking that position. In the first instance, the defendant makes repeated references throughout his submission to a perceived lack of any factual basis for our motion, especially as regards evidence of actual bias. I'd like to remind the defendant that we are not submitting our motion to a third-party referee in this case. In fact, you were, of course, the trial judge, a person very familiar with the underlying facts, and it was our reasonable assumption that since you had served in that role, there was absolutely no need to provide you with any detailed factual recitation regarding the events of the prior trial. To the extent that you believe that we were somehow remiss in failing to include a more detailed factual recitation, I can only hope that Mr. McCauley's presentation today clarified those issues for you and for defense counsel. Next, the defendant, without expressly saying as much, has tried to insinuate a novel theory into this hearing. Specifically, he's trying to suggest that somehow, I don't know quite how to characterize it, but the doctrine of unclean hands or some close cognate of that applies here. And if I understand the defendant correctly, he's trying to suggest that because it was Mr. McCauley who first spoke to the press regarding the Duarte matter and the bias that he had observed and has described today in those proceedings, that we are somehow now stopped from pointing to the adverse media impact of your appointment to this case as a basis for recusal, and that is simply not the law. In the first instance, Mr. McCauley did nothing wrong in speaking out in the manner that he did.
Okay, so you're relying on the proposition that when an attorney or litigant goes to the press and the press reports on that, that in turn can then the fact of that publication.
Well, we cited Webster in our brief that we filed, a memorandum we filed in support of our motion, and I'd also point to
Point me to what case in your memo stands the proposition that a judge is deemed, or there's an appearance of impropriety by virtue of the fact that an article has appeared containing criticism of the judge by a litigant or an attorney.
Well, respectfully, Your Honor, it was not our position at all that simply the fact that Mr. McCauley had spoken to the press, that therefore that creates a basis for recusal. So I would...
Do you have any case, or is there any case?
If that were the only issue here, Your Honor, we would absolutely not be here today.
Thank you.
You know, and I to pick up with this notion of sort of estoppel or unclean hands that the defendant has urged in his submission, there are lots of instances where unilateral action can provide a basis for recusal, as long as it's grounded in some extrajudicial influence, such as the media influence, as in this case. I mean, the very authority cited by the defendant recites that only baseless, is the quote, baseless allegations are subject to any such estoppels. And as Mr. McCauley has made plain today, I hope our concerns are anything but baseless. And this brings me to my final point, Your Honor. Mr. Fee and Mr. Sultan, in their submission, have questioned the government's motives in bringing this motion, telling us in footnote 4 of their submission that we should somehow be ashamed of the seriousness with which we have approached this matter. You know, first let me say that I'm disappointed that they have taken that tack. It certainly is not typical of the approach that we've taken in the matters that we've argued before the court, in this case heretofore. I'd also like to point out that our current motion is entirely consistent with our past practice before you, as evidenced by what we did in the Durand case, and it's been discussed today. And so it simply can't be viewed as the defendant, I think, would have it.
Why is there a response to that? Because wouldn't the response be that in that case, the same bases for filing, therefore, when I guess I'm trying to see why the fact that one previously filed it, I'm not saying subscribe to the arguments, but if one filed something for improper purposes today, the fact that one previously filed something, why does the previous filing not reflect one way or the other, or whether someone had those same purposes when they filed it last time?
Because, Your Honor, in the defendant's submission, he made it perfectly clear that at least one of his points was that we were capitalizing in some way on the intense media scrutiny that has settled on this case, and taking advantage of that by filing this motion, assured that it would be widely reported in the press. That was a tactical motivation for us to file the motion. No such tactical motivation existed in the Duran case, which was a case that was covered profoundly differently by the press. And so there simply is there's no way to compare the two situations, and it utterly destroys any notion that our motivation for filing in the Duran case was to capitalize on such media coverage, any more than that's our motivation today. I guess the most troubling aspect for me of the defendant's submission is the extent to which it misperceives our basic motivations in pursuing this matter. And to the extent that our motivations were not made clear in our own motion, let me make them crystal clear today. We have basically three motivations. One is to try this case in an environment that protects both the people's right to a fair trial and the defendant's right. Second, to obtain a verdict that reflects a fair and impartial view of the evidence. And third, to obtain a verdict that will withstand appellate scrutiny so that we can have the finality that the victim's family, that the defendant, and that the public are entitled to in these proceedings. And I guess what worries me most about what has happened heretofore in terms of the appointment process, that is the assignment of you to this case, Your Honor, is the impact of the media on this case and the extent to which your appointment will affect that. As I pointed out in our motion, at this point it's more than 10,000 stories have been written about these proceedings already. And I can tell you the government intends to do absolutely everything that it can between now and the last day of trial to maintain an environment that fully supports the fair administration of justice. And with all due respect, Your Honor, it's my personal judgment that your assignment to this case, with the documented media baggage that it brings, will constitute a completely unnecessary distraction that could imperil the verdict here and affect the finality of it. And Your Honor, I have to tell you that I say that with full empathy to your situation. I was a member of the parole board during the time of the Sinelli murder, and the governor fired 5 of my colleagues. And Judge Archie and I ran the board for 6 months, and we conducted 1,000 hearings under a media glare that is not much different than what is present here and has been throughout this case. And I don't remember how many times inmates asked me to recuse myself from hearings because they simply didn't believe that I could arrive at an impartial decision in that case because of the relentless media focus on the question of my neutrality in the wake of the Sinelli incident. And I can tell you, I never recused myself once, believing wholeheartedly that I could, in fact, be neutral in spite of the impact of the press. I thought I knew better, I suppose, but I can tell you this. At the end of the 6 months, I checked, and in fact, my paroling rate was down by about 20%. And so I put it to you, Your Honor, that no matter how objective you think you can be in a situation like this, and I think you need to consider that separate question carefully in light of the presentation that Mr. McCauley made today. But the fact is that the attention the press pays to the question of your neutrality will, in my view, and based on my own personal experience, inevitably affect your decisions in the end. And even if it doesn't, the risk of the perception that your judgment has been impaired remains for all the reasons we articulated in our motion. And I'm frankly surprised, I have to say, that the defendant doesn't, to some degree at least, share our concerns in this regard, given what has been a steady drumbeat of complaints about the media dimension of these proceedings so far. If I were to follow the defendant's example, I suppose, I might question their motives, their dedication to achieving not just a fair verdict, because I think we're all on board with wanting to accomplish that, but also finality and closure to these proceedings. I hope that we're not going to be standing in the SJC a year from now, hearing from the defendant how the very circumstances about which the Commonwealth has complained today has prevented the defendant from receiving a fair trial. For all these reasons, and with truly, Your Honor, the deepest respect for you and for the office that you hold, the Commonwealth would ask you to recuse yourself from these proceedings. Thank you very much.
Thank you. Mr. Sutton.
Good afternoon, Your Honor. I am not here to give personal testimony. I am here to make a legal argument in opposition to the Commonwealth's motion. As the Court knows, Your Honor was specially assigned to this case on September 17th by the Chief Justice of the Superior Court of the Commonwealth, pursuant to her authority and duties as Chief Justice. The Commonwealth has now moved, unhappy with that choice, the Commonwealth has moved to effectively invalidate it and replace Your Honor, based on the allegations that Your Honor is biased against the Commonwealth and that for Your Honor to preside over this trial would create an appearance of unfairness. These are serious charges, Your Honor, and I think that which go to the integrity, the very integrity of our system of criminal justice. In our filing with the Court last week, I think we demonstrated quite clearly that the Commonwealth's motion is utterly devoid of any factual or legal merit. And I don't want to waste the Court's time by reiterating everything that was in my filing, but if I may, I'd like to focus on a few key points and respond to the argument of the Commonwealth. At the outset, it is clear that a motion to disqualify or recuse a judge must rely on a specific showing, a specific detailed showing to justify such drastic relief. In this case, the Commonwealth has made no showing, no quotations, no citations to the record until today, when Mr. McCauley sort of ad hoc gave some recitation of some things that happened at this 3-week-long trial. I had no idea what they were relying on. Your Honor, that is not sufficient. That is abysmally short of what is required for any party to seek relief of this type. And in fact, it wasn't until I pointed out in our filing, by the way, they haven't even submitted the 16-volume Duart transcript they are relying upon, apparently either to the Court or to counsel, that they submitted it. Now, I don't know whether they expect defense counsel to plow through those 16 volumes and find out, look for some spot where Your Honor was allegedly unfair, or whether they expect Your Honor to do that. But that is not how our system operates, Your Honor. I argue a lot of appeals. I would not go to the appeals court and say, here's the record, the trial of my client was unfair, you figure it out. Their burden on something like this, particularly on something of this seriousness, Your Honor, is to provide specificity, and that they have utterly failed to do. And I'm amazed at the argument that counsel makes today, saying, well, Your Honor, we don't have to provide you with specifics. Your Honor was there. That's not how our system operates. They are obliged, and the SJC in the Demoulas 4 case makes clear, you've got to provide time, place, specificity if you're alleging such bias, such unfairness that a judge, a sitting judge, should recuse herself. And the fact that Your Honor sat on that case in no way lessens their burden under the law to demonstrate that there is a compelling reason for the kind of relief that they're seeking. Moreover, Your Honor, the 3 specific grounds that the Commonwealth articulates for recusal are all completely devoid of any factual or legal merit. First, they complain, and again, Mr. McCauley did it today, about some of the rulings that Your Honor made at a murder trial that he and another prosecutor tried before Your Honor 3 years ago, the Duart case. And I think today's argument is a very good example of why every court that has looked at this issue has said complaining about rulings is not a ground for recusal. All of us as lawyers face rulings from courts that we don't like. That's part of being a litigator. But the fact that a judge may have ruled against me in a case does not allow me to have a lifetime exemption from appearing before that judge again. That's essentially what Mr. McCauley is looking for here. So it is clear from the case law that we have cited, and they have cited nothing to the contrary, that disagreeing about rulings made by a court, that disagreement does not establish a bias to support recusal. And that's the first ground that they rely upon. And I should point out, Your Honor, it's ironic that they make that argument because, number one, Mr. Duart was convicted of murder. And number two, in his appeal, which is ongoing, Mr. Duarte's appeal from his conviction, which is scheduled to be argued before the appeals court next month, Mr. Duarte complains about some of the rulings by Your Honor. Mr. Duarte complains in his brief that Your Honor allowed in all kinds of bad acts evidence, which Your Honor should not have allowed in. So, as in most trials that are tried by a judge, there are some rulings that favor one side and some rulings that favor the other side. That's the way it goes. And as Mr. Segadelli says in his affidavit, and he was the defense counsel at trial, there was no pattern. Basically, the court made rulings, Your Honor called them as you saw them. And there were some rulings that favor the Commonwealth, some rulings that favor the defense. That's the way trials are. That ground is utterly without merit, factual, legal, and again, Your Honor, other than these anecdotes, which I'm in no position to respond to because I don't know what page, what volume he's talking about, again, that is not the way to bring a record before any court, particularly in a matter of this seriousness, in a first-degree murder case. Now, the second ground that the Commonwealth recites, and they do it only by reference to their motion they filed in some other case, Durand, is they say that Your Honor was discourteous and disrespectful to Mr. McCauley during the course of that trial, that they complain about Your Honor's tone in presiding over that trial. Now, once again, Your Honor, there are no citations to the record. And there are no, of any kind, there's no specificity, either in the memorandum, in Mr. McCauley's one-page affidavit filed in Durand, there is no specificity about exactly what they're complaining about. And it's this kind of broad, conclusory allegation which the SJC, which the United States Supreme Court, which the Court of Appeals for the First Circuit and other courts have said, that's not enough. We're not going to allow a party to essentially disrupt the system and try to change a judge, try to have a role in the selection of the judge based on some conclusory allegations like that. That is essentially what they have put before the court, and that's not good enough. And moreover, Your Honor, as the cases that we cited in our memorandum make clear, in any event, as a matter of law, that's not good enough. A judge can, trials are stressful situations, and the fact that a judge, and I'm not suggesting any of this happened, because I wasn't there, and I have not read the 16-volume transcript, but if a judge is abrupt with a lawyer, if a judge is impatient with a lawyer, if a judge is angry with a lawyer, as the Supreme Court, 4 justices of the Supreme Court said in the case I cited to Your Honor in the memorandum, that's not good enough for recusal. That's part of life. We all have to deal with that. That does not rise to the kind of level, the kind of extreme level that would be required for a party to make a showing to justify this drastic remedy, which is we don't like the judge that was specially assigned by the Chief Justice of the Superior Court. We want a new judge. That's not the way our system works. That's their second ground. It's without any legal or factual support. And finally, Your Honor, their third ground. And their third ground is basically the one that says, well, there have been reports in the media that there's antagonism between Mr. McCauley and Your Honor. And because of that, because of those reports in the media, Your Honor has to recuse yourself. And that to me is just an amazing argument, I think. I mean, number one, any antagonism that may exist is unilateral. It was Mr. McCauley who chose, after the Duarte trial, to publicly criticize Your Honor to the media. He did that. And Your Honor, quite properly, did not respond in any way because the judicial canons of ethics proscribe you from doing so, among other reasons. And as courts have said, the First Circuit said in the case I cited to Your Honor, judges are not supposed to talk to the media about pending cases, even when there's a misrepresentation. Part of being a judge is that you have to let that stuff roll off your back. That's part of the temperament of being a judge. That's why it's one of the reasons it's such a difficult job. So Your Honor didn't respond. There's no mutual antagonism as alleged in the Commonwealth's motion, again, without any record support of any kind. And they say, well, you know, it's reported in the media. You have to recuse yourself because there are these media reports, and we have to worry about that. and as the cases I've cited to Your Honor show, that is exactly what we don't have to do. And in fact, it is a job of the judge in this kind of situation to ignore those media reports. It doesn't matter what the media writes. It doesn't matter what they write about antagonism or dispute or conflict. That is, in fact, something the judge is obliged not to consider. Whereas the Commonwealth thinks that the media apparently should be deciding. In our system, it is not the media who decides who will preside over a case. It is Your Honor who makes that decision consistent with the law. And so their idea that somehow, because to do otherwise, Your Honor, as these cases have said, would allow somebody, a party who has access to the media, a party with power, for example, the district attorney, to basically manipulate the system. Of course the district attorney has access to the media. So if in a different kind of system, the party with power who's got access to the media could plant whatever stories they want in the media and then say to the judge, aha, Your Honor, look at this story. This story says that we have antagonism, therefore, see you later. We want somebody else. That's not the way our system works. Thank goodness. In sum, Your Honor, the Commonwealth's motion is utterly frivolous. It's utterly frivolous as a matter of fact, where there's not even any factual showing, let alone the kind of showing that would be necessary to support this kind of drastic remedy, and it's utterly frivolous as a matter of law. And yes, Your Honor, we do ask in our response, although apparently the Commonwealth takes umbrage at our even raising this, why the motion was filed. Because it's so clearly devoid of merit that I think you have to ask yourselves that question. The Commonwealth has said over and over again in public they have a strong case against Mr. Hernandez. Well, if they have such a strong case, if that were the truth, why are they trying so hard to manipulate the choice of judge? And however they want to couch it, Your Honor, that's what they're trying to do. Your Honor, I have no way of reading their subjective intent. I don't know whether they filed this motion in an effort to intimidate Your Honor or to influence Your Honor on future filings that are going to come before the court in the course of this case, and there will be many. I hope not, but it raises a concern to me that that's what's going on here. And Your Honor, the Commonwealth does not have the right to do that. They don't have the right to manipulate the system. They don't have the right to manipulate this court. And for all those reasons, it's frankly, it's important that this motion be denied and denied quickly. A motion like, and the cases say that, when a motion for recusal doesn't have merit, it should be thrown away. It should be rejected in the strongest possible terms, and I ask the court to do that. Thank you, Your Honor.
I've had the benefit of the Commonwealth's motion and the filed transcripts and the party's memorandum of law before today, and I have reviewed all the transcripts. I have carefully considered the arguments. I am ruling at this time and will be issuing a written decision in the next few days. The Commonwealth's motion for recusal is denied. I harbor no bias against the Commonwealth or against First Assistant District Attorney William McCauley or against the defendant. I am free of any disabling prejudice towards the Commonwealth and its attorneys. Considerations other than the law have not and will not influence any of my rulings. I do not fear or favor the Commonwealth or the defendant. A person aware of all the facts and circumstances would not reasonably question my impartiality. With respect to the alleged bias against the Commonwealth, the motion for recusal focuses upon a 2010 case in which ADA McCauley represented the Commonwealth. Some of my rulings in that case were in favor of the Commonwealth and some were not, as is the case in all of the other criminal cases over which I have presided over the last 20 years. This is not the place to analyze the rulings made in that case, the reasons for which are articulated in the public record. The defendant in that case was convicted of murder in the second degree. The appeal of that conviction is pending. As the appeals court has stated, the mere fact that a party suffers adverse rulings during litigation does not establish lack of judicial impartiality. To the extent that the motion seeks that I recuse myself for bias against ADA McCauley in that case, there is no basis for me to do so. I have examined my emotions and consulted my conscience, and I am satisfied that I harbor no bias as a result of anything that may have transpired in the 2010 case, or by virtue of ADA Macaulay's reported out-of-court statements to the media following that case. The Commonwealth argues that recusal is required because public confidence may be shaken in view of the, quote, well-known and publicly documented history of antagonism, end quote. There is no documented history of any antagonism by this judge toward ADA Macaulay. As far as ADA Macaulay's views of this judge, the only history consists of one local newspaper article, a follow-up letter to the paper, and a newspaper blog posting, all within a 10-day period in 2010. The article attributes remarks critical of this judge to ADA Macaulay. It also states, quote, Gosh declined to respond to Macaulay's remarks when approached in her chambers. She said she is prevented by the judicial canon of ethics from responding because an appeal in the case is possible. The blog post briefly reiterates the substance of what ADA Macaulay apparently had stated, and the letter commenting on the remarks attributable to him. And it contains statements from the defense counsel in that case. It also includes the statement that Gosh had said that the judicial canon of ethics prevents her from responding to that statement. An objective reader of these materials would not reasonably question my impartiality. Instead, the reasonable observer would only conclude that in our adversarial criminal justice system, one or both adversaries is often unhappy with the rulings of the judge. As one United States Court of Appeals has pointed out, quote, a judge must continually rule against one party or another. No judge can be so sanguine as to believe that he is never the object of disapproval and criticism directed to something more personal than his abstract judicial actions. If such disapproval is brought openly to his attention, he does not automatically change from benign to biased. The Commonwealth points to the fact that after the special assignment in this action was documented, the 2010 statements attributable to ADA Macaulay resurfaced in the media. The Commonwealth cites one such story that appeared in several media outlets. The Commonwealth states that this article recited, quote, several past points of conflict, end quote. It did not. It simply referenced the 2010 statements. The Commonwealth also argues that, quote, the relentless public focus on any signs of friction between judge and prosecutor that this initial story augurs might reasonably impair the ability of each to exercise his or her sworn duties effectively. Indeed, this is already arguably the case, end quote. I am confident that my ability to be fair and impartial to the Commonwealth and to the defendant has not been and will not be affected by that story or any like stories, and that an objective person would not reasonably question my impartiality. That the Commonwealth may believe that ADA Macaulay might be impaired in the performance of his duties is not grounds for recusal. Finally, the Commonwealth argues that it is immaterial whether the media has accurately reflected the true status of what the Commonwealth characterizes as the parties' relationship, because, quote, this history will be exploited and sensationalized by the media before and during trial. Publicity alone, as the federal district court judge has ruled, quote, cannot create a reasonable doubt as to the judge's impartiality. The mere fact that the issue of disqualification has drawn the attention of the media, resulting in extensive coverage, is not in and itself a good reason to reassign this case. The adoption of this view would lead to judicial abandonment of responsibility for the purity of the judicial process and ultimately undermine the independence and integrity of the courts, end quote. When ADA Macaulay apparently chose to make remarks to the press in 2010, he knew or should have known that his statements would create the very history the Commonwealth now is using as the basis for seeking recusal. To require recusal in these circumstances on the theory that there is an appearance of bias arising from media reports would allow attorneys to use the media as a device to set up a judge for future recusal. In effect, by complaining about a judge to the media, thereby generating news stories, An attorney would have the means to exercise veto power over a judge he or she did not wish to hear that attorney's cases. As our appeals court has stated, the rules governing the recusal of a judge are not intended to provide litigants with the means of obtaining a judge of their choice. The issue of whether a judge should recuse herself because of publicity is not a novel one. Numerous courts have held that criticism of a judge in the media is not sufficient to support a charge of bias on the part of the judge toward the critic. For example, the United States Court of Appeals for the First Circuit has stated, quote, "To find otherwise would allow an irresponsible, vindictive, or self-interested press informant and/or an irresponsible, misinformed, or careless reporter to control the choice of judge," end quote. A federal district court judge wrote, quote, "Only a psychic pleader could allege that because a defendant has published uncomplimentary statements concerning a judge, the latter will be unable to give his critic a fair and impartial trial. If such a fantastic procedure were permitted, a defendant could get rid of a judge by the simple expedient of publishing a scurrilous article, truthfully alleging that the article was published, and clinching the matter by asserting the bold conclusion that since the article was uncomplimentary, the judge must of necessity be prejudiced against the publisher. For all of those reasons, the motion for recusal is denied. We have a scheduled next date. Is there any other matter to be taken up at this time? I just want to let the parties know that I will be putting in the case file the transcript for July 17, 2010, which was not included in the Commonwealth's filings, and I'm also putting in the case file of this case, the court's endorsement of the motion to recuse filed in the Duran case, which states, "No action taken moot without this judge's knowledge. The first session continued the trial in this matter to a date that conflicts with another murder trial this judge is handling. Accordingly, for that reason and for that reason alone, for that reason only, the case will be transferred to the other trial session, which will schedule a final pretrial conference." Thank you.
Thank you, Your Honor. Court all rise.